Your mom passed away recently in Florida. You're the one that's named as an executor in the will. Your siblings are pressing you to get the property sold as quickly as possible. Before you even have a chance to think about it, a neighbor presents a contract, and everyone wants you to sign it. You do, even though, against your good judgment, you haven't had a chance to talk to a Florida lawyer. A few weeks later, the buyer is threatening to sue. He tells you that his attorney tells him that you did not have the authority to sell the property, and also the inspection revealed mold. Now one of your siblings is saying that you moved too quickly and you sold the property too cheaply. What do you do now? Hi, my name is Brian Duffy, and I'm a Florida lawyer. Welcome to Duff Law Digital. Today I'm here with my colleague and my associate, Sydney Smith.
Hi there.
Welcome, Sydney. And we're going to talk today about Florida homestead properties and some of the issues that can arise with probate and homestead property in Florida. So if you want to learn about Florida homestead, stay tuned.
So Brian, that scenario highlights a lot of the things that we run into in selling a Florida probate property or a Florida homestead property. So let's go through those key issues one by one.
Sure. So one of the first issues is in the fact pattern that we laid out there. Someone was named as executor, or in Florida we call it personal representative, in the will. One of the first points is that even though you may be named as an executor or personal representative in the will, you don't actually have the authority of the court to deal with the property and to enter into contracts until the court accepts the will and names you through letters of administration, gives you the legal authority to enter into contracts.
Right. Right.
So, of course, in Florida, there is a concept under our case law that says that someone who acts on behalf of the estate and does so in a way that benefits the estate, even prior to being named as the executor under the court system, that contract may be ratified by the court later on. But that's not a position you want to be in, that you hope it's going to work out.
It's not, especially if the heirs of the homestead property are saying that you are selling it for under market value.
Right.
So.
And Sydney and I have a very conservative approach in how we conduct probate administrations and sale of real estate and things like that. And a lot of times when we're talking with clients, they'll say, well, that seems like a little bit too conservative. But what we found over the years is if you take your time and you're careful and you make sure that you're protected, you're not exposing yourself to potential arguments. So one of the things that we'd advise that client if they contacted us early on is that we would say, hey, let's get all the heirs involved in this issue and make sure everybody's satisfied. And even go to the court, which is not a difficult thing or an expensive thing, but it really helps a lot in avoiding problems and getting a court order authorizing the sale of the property. But let's talk a little bit about the homestead aspect. So here we have a Florida homestead, according to the facts. And Florida homestead is, it's sort of funny, right? I mean, it is and it isn't part of the probate administration. Why don't you talk about that for a second?
Right. So like Brian said, it's not considered a probate asset that is subject to estate creditors. But a homestead property for this purpose is only considered homestead if the court says that it is. So many times a title company, when you're purchasing a home, will require that you get an order determining homestead from the court, which says this is the homestead and it's protected from the creditors of the decedent.
Right. So Sydney's pointing out an important thing here. Everyone knows that under the facts, this was probably the homestead of the decedent because she lived in Florida and this was her only home. So it couldn't be a situation where she was a Florida resident and she had two homes.
Right.
One would be homestead and one wasn't. So we all knew this was homestead, but like Sydney points out, you don't really have the legal authority of determining it's homestead without the court saying that. And secondly, again, as Sydney points out, the title company may want to have that order determining homestead because that will indicate who exactly are the heirs that are entitled to the homestead, and then that's going to be a muniment of title, sort of like a deed in the public record, showing that when mom died, the following four children of mom were the heirs of the homestead, and therefore that was, how the transfer of the estate went. Let's talk about some other things, because homestead, and this is kind of an interesting area because this comes up all the time, right? So somebody calls the office, and let's say they're talking to Sydney or me, and they say, we want to get this property sold. We want to go ahead and we want to get, letters of administration and get appointed, but we need to move quickly. We've got a buyer, and we're a little concerned that the buyer's going to go away, and we've got a good price that we've talked about, and everything looks great as far as, cash offer and, quick closing and all those kinds of things. So what do we do, Sid? I mean, you got to get it sold fast, and you have to deal with the courts. So that's kind of like two different things working against each other.
Right, right. So if you've ever been in a situation where you're having to sell a homestead in an estate, you may already know this, but essentially, in order to get the order, you are required to notice creditors once the estate has been opened. So it usually takes at least a couple of weeks to get the estate opened, and then from there, soon after, you would publish the notice to creditors in the local newspaper, and you would directly serve all known creditors. And the creditors have a period of the later of 30 days from receipt of the direct notice or 3 months from the date of publication. And the court won't hear the petition for homestead until that creditor period has expired. So this frustrates a lot of clients because, they're thinking, well, not only do I have to wait a few weeks to get appointed, but then I also have to wait 3 months to put the home on the market and sell it. And, we've got a buyer ready. So we have a way that works with most of the title companies' requirements where instead of pursuing the homestead order first, what we would do is get an order authorizing sale, where once the personal representative is appointed, we immediately submit the petition with a copy of the contract to the court, requesting the court's approval of the sale price and terms. Then we get the order authorizing the sale, which usually satisfies the title company. And in the order, we have the court say that our firm's trust account will hold the proceeds of the sale until a determination of homestead has been made. And at that point, when we get that order, we release the funds to the natural heirs of the decedent.
Right. So one key part of that was that the heirs would have to agree, because if it was homestead,
right,
they're the ones that really own the property.
Right.
But the process that you just outlined is a way to sort of resolve the issue, the tension between the two facts, that it's homestead and we want an order determining homestead, and we don't want to delay the sale of the real estate. Right. One thing that we found over the years with Florida judges is that Florida judges seem to have a real empathy for estates that are trying to sell real estate. Many times, Sid or I or our paralegal will get on the phone, we'll talk to a JA, and we'll say, look, here's the situation. Please tell the judge that the family has a contract that looks like a good buyer. If we're not able to get this sale, it could harm the estate. And so we need to have the court work with us to try and get an order as quickly as possible in order to preserve the sale for the estate. Many times judges will go out of their way, and our judges are incredibly busy. They've got stacks of files on their desk, and the process through the probate courts can be very tedious and can be very aggravating for attorneys and clients and judges as well. But they'll kind of move along on most cases so that we can get something sold and we can protect the estate.
Right, right.
Yeah. What else were we going to talk about? Okay, another point that was made in those fact pattern was the issue of mold and whether or not the seller had a duty to disclose the mold. So one of the things that we tell our clients when they're dealing with, let's say, mom or grandmother's or granddad's house or apartment or whatever, they really aren't in a position to state whether or not there are any issues with leaks or other things. And typically on a listing agreement or on a contract, they'll put in there something about whether or not there's, any leaks in the roof. Or the important point there is not to make any affirmative statements assuring the facts, because you may not know the facts. In fact, you probably don't know the facts. So if you were not in possession of the property, remember mom was, or dad, or your grandparents, then if I'm doing a listing agreement on that kind of property, I would say I'm not, I have no facts. I wasn't living in the property, so that you're not getting yourself in a situation where you're affirmatively stating that there are no leaks and that, that's something that maybe you should have disclosed. The other thing we tell clients in the situations like this is to definitely list the property as is, because we don't want to get into repairs and we don't want to get into a problem. One of the things we find in Florida that sometimes if we hire a worker and we pay the worker to do work on the property, and the estate is out of the money to do the fixing of the plumbing or the air conditioning, whatever it is, if that's not done in a workmanlike manner, and it's not done under the standard, that would be expected of a professional in the Florida community, then the seller could be brought in to have to fix a problem several months later, even a year later. So the best thing, for us in our minds is to sell the property as is. If there's an identification of a problem, and let's say, the best estimate is going to be $3,000 to fix the problem, negotiate between the buyer and seller and provide them with a credit, let them get their own worker. Many times the buyers appreciate that.
Right.
And then they're sort of in the driver's seat. They hired the guy, they paid the guy, and now they're living in the house, and if there's a problem, they can call him back.
Right.
Yeah.
That's definitely the preferred way to do it. So.
What are some of the other issues that you see on Homestead that we haven't kind of addressed yet?
So one thing that you had mentioned, we spoke about a little bit earlier, was the fact that Homestead is not really an estate asset, but one thing to note there is that the personal representative who's in charge of the estate, they have the authority under the Florida statutes to go into the homestead and take possession of it in order to prevent a wasting of that asset. So that means, changing the locks, getting repairs done on the property if it's needed.
Making sure the air conditioning's on.
Exactly.
Yeah.
So even though it's not an estate asset, it is within the jurisdiction of the personal representative prior to getting the homestead order, which at that point, once you have that order, it's then the property of the heirs. Now, if the personal representative expends estate funds to fix the homestead property, then the personal representative has the ability to put a lien on that property for the cost of those repairs in favor of the estate. So, and that lien takes precedence over any other creditor claims in the estate.
That's an important point, because what a lot of people don't think about is you could have a different set of beneficiaries who are heirs of the homestead and who are beneficiaries of the estate. So if the beneficiaries of the estate are like A, B, and D, and the beneficiaries of or heirs of the homestead are A, B, and C, you've got different people on either side. So if somebody is a beneficiary of the estate, he doesn't want the PR to spend $5,000 or any amount of money on the homestead that he's not getting. And so if the PR does expend that money, like Sydney's pointing out, under certain facts and circumstances, if the action was required in order to preserve the homestead, then like Sid said, we can get a lien on the property, which means if the property is sold by the heirs, we can get the estate reimbursed the amount of money that was spent.
Right.
Yeah. Good.
So, Brian, there are some interesting elements to the sale of Florida homestead when the owner is not deceased. Can you tell us a little bit about that?
Yeah, I think what you're referring to is portability.
Right.
So portability is an aspect of homestead that we all get, and it can be something that can be very effective for our clients. And a few years ago, the Florida legislature passed a law that enabled us to take some of our benefits in homestead from one house to the other. The problem was there were a lot of people that had been Florida residents for many years that had this benefit, this ad valorem tax benefit for several years in a property, and if they were to move to another property, they would give up that benefit. So it was causing a bit of stagnation in the market because some people weren't moving.
That's a great point. So can you explain for our viewers exactly what we're talking about with this portability benefit?
Sure. So as many viewers may understand, in Florida, when you own homestead property, and once you notify the property appraiser that you qualify for the homestead exemption, you get a special exemption on your ad valorem tax. And the exemption amounts to setting a cap year on the value of your home. So once you qualify for Homestead and once you notify the property appraiser, they set a cap year. Let's say it's 2018. They take a look at whatever the assessed value is in 2018, and then your property will not be increased in assessed value any more than the lesser of 3% or the CPI. So if the CPI that year is 2.5%, they'll only increase the assessed value of your home by 2.5%. If the CPI is 7%, they only increase the assessed value of home by 3%. So it's a lesser of 3%. And that's the ad valorem benefit. So what we were talking about, and I think we have a slide that we're going to put in here too. Sid did a great job on the slide. But what we're talking about is, what do we do when a client has had this benefit over a period of years, and it could be substantial sometimes. I think in our example, the ad valorem benefit is up to like $150,000.
Right.
So now the client comes to us and says, I want to buy a new property. And why don't you walk us through, if they're going to increase value, they're going to go from a $400,000 home to a $600,000 home. How does it work? How does the portability increase work?
Okay, so in this example on the slide, we've got Jeff and Jen. And Jeff and Jen, let's assume we're taking the upsize example, where they're deciding to purchase a more expensive home. So their current homestead the fair market value is $400,000. And in order to find the portability benefit, you'll subtract the assessed value of $250,000 from the fair market value, which is $150,000. So if they decide to upsize to a home with a fair market value of $600,000, you'll see at the top right-hand corner how to calculate the taxable value. So first you'll subtract out the portability from the prior home, which was $150,000, and that way you get the assessed value of $450,000. Then from that, you'll subtract out the $50,000 homestead exemption, and that's where we get the taxable value of $400,000.
Right. So that's a great example of how exactly this new legislation, or relatively new, I forget, it was a number of years ago when it came in, but that allows somebody to take their benefit from one house to another, so they're not stuck in the same residence, because they don't want to give up that homestead benefit. Now, let me run through the scenario on the downside. What if they were going to go to a house of lower value? Right. So in the illustration, what you'll see is, again, starting out, their present home is a $400,000 fair market value. Their assessed value is $250,000. That's because several years they had that 3% cap, and therefore the portability benefit is $150,000. Now, they went from a larger house to a smaller house, the kids moved away, whatever the reason is, and they go from a $400,000 home to a $200,000 home. As you can see in the example, what they're going to do is they won't be able to get the full benefit of the $150,000. In this example, since the new home is about 50% of the value of the old home, they're only able to port over 50% of the benefit. So instead of porting over 150, like Sydney showed us on the upsize example, in this example, they poured over $75,000. That gives them an assessed value, an adjusted assessed value of $125,000. And then again, we subtract the homestead exemption, which is a separate line item, breaks it down to a taxable value of $75,000. So they purchased a new $200,000 home, they brought over half their portability benefit, and they ended up with a taxable value on a $200,000 home of only $75,000. This is how portability works. There are some technical steps that we need to work with the client to make sure that they're able to take advantage of this benefit, but it's not that hard to do, and it's a great benefit for our clients.
Definitely.
So that's it for today, and we hope you enjoyed our video on some of the key issues on Homestead in Florida real estate. Sydney and I are going to do several different videos coming up on Homestead because, there's so many things that we could talk about, very important things.
There really are. It's hard to cover it all just, in 15 minutes. So.
Absolutely. And, there's books and books that are written in hundreds and hundreds of cases in Florida on Homestead. So there's a lot of issues we're going to talk about. We're going to talk about creditors, which we didn't have a chance to talk about here today, and how to transfer creditor protection from yourself to your heirs and all those kinds of things. We hope you enjoyed our video today. If you did, please give us a thumbs up. It helps other viewers find us on YouTube. Remember to follow us on Facebook, the Duffy Law Firm Facebook page. Duff Law Digital is on LinkedIn, Instagram, Twitter, and Facebook. We post at least a couple times a week, and these videos are intended to be a service to our clients and the general public. We hope you enjoy them, and if you do, leave us a comment. Let us know what you like, what you'd like us to do in future videos, and don't forget to keep watching. Thanks for watching. Wow.
I don't know. I gotta look.
What else?
I don't know.
I'm just kidding.
That's it, you're wrapping.
That's it. I'm just going to wrap.
Okay, thank goodness.
You just wanted to torture Sid.
I love torture, Sid.